Should the judge recuse himself? Yes. Should a mistrial be declared in this case? Yes. Is this entire trial becoming a waste of time, resources, and reputation in Georgia? Absolutely. I really feel like this case has become unhinged.
Hiya YouTube, welcome back to my channel. If it's your first time here, please comment and subscribe. If it's your first time ever seeing this, subscribe, join my village. It goes a long way, as you guys already know. And before I get started, everything I'm about to say regarding this situation, this topic, and everything else is absolutely my opinion. I am not trying to incite any violence within the people or try to create any division or anything altogether, and I am not accusing anyone of doing anything that is illegal or they have not done. Now, with that already put out of the way, this is an update to the YSL RICO trial, Jeffrey, aka Young Thug, right? And this whole situation with the judge. I know I'm a couple of days late, 6 days ago when it happened, and it's been cuckoo bananas. I have not been this entertained by a court proceeding since R. Kelly's proceeding when he pissed on that girl. And I'm still pissed about that. But you know what? Pissed. I digress. It's a hot mess. That there was a time when there was respect for the laws anywhere, right? But if you want to live in a world where you think that the justice system will always be here to prevail and to help you, then wear a helmet. In the words of Candace Owens, right? But this entire YSL RICO trial is more entertaining than all my children, all of their years, all of their seasons, all of their plots. This is the best. I would not be surprised if we see a movie in the future, or a docu-series, or any type of short series, anything regarding this whole hot mess of a situation. Now, with that being said, you guys already know what I do here. I got together the most coherent videos, the ones that made sense, the best ones that I could find, to basically break down and explain to you what is going on in this case. And in my understanding, YSL RICO trial, the judge has recused himself because he was dirty, and now the next one is on hold until they find a different judge that will be fitted. So if you guys don't know, in order for a judge to be removed from his position, from his case, a judge that's above that judge, who is that judge's boss, have to look over the paperwork and appoint someone else, right? So this is a hot disaster, just straight up disrespectful, if you ask me. Disrespect of the law is unprofessional, it's sickening, excuse my voice, it happens. But without any further ado, I'm getting out of here. I need to get some tea, and you guys need to check out these videos. Hope you have a good one. Bye.
Is this something that we can expedite? I mean, the state does have very concerns that we hold the jurors indefinitely regarding this matter. Is that anything that could be expedited so that those decisions can be made on the motion of recuse and we can move forward with the trial?
While I understand your concern, I think the rules of transfer and recusal are pretty clear. That I'm not going to comment on anything that is pending at that point in time. So hopefully it will get done fairly quickly in terms of somebody acting on it. Okay.
All right, thank you, Your Honor.
Okay. Anybody else? Mr. Steele, you rose just a second ago. Did you want to say something, sir?
No, I thought you were recessed.
Okay. All right. Okay. Okay. Then we're in recess, and we'll see you in a little bit. Okay. All right. We're in recess. Consideration of this emergency nature, the court is taking into account a couple of cases I'll cite for the record. United States versus Adams.
Oh wait, he's citing cases to defend himself. Here we go.
Although an ex parte conference to discuss threats against the witness is proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed.
So he's citing a case where the actual subject of what he's going to testify about wasn't the issue, it was whether or not he was scared to testify?
Adams, the appellants contend that the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations the trial judge may find an ex parte conference necessary. In the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about the threat. A witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony. Only promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed.
You didn't disclose it. You just cited a case where they should have disclosed it. They never disclosed anything to the defense. They were completely in the dark for hours waiting for the trial to start.
Similarly, in this matter, the only thing discussed between the state counsel for Mr. Copeland and this court were the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to.
Someone's lying then. Did he ever admit to killing Donovan Thomas? That's what he would testify to. Bro, are they about to release a transcript that's like not right? I'm gonna be super freaked out if this transcript doesn't have that in it, because then that means someone's lying, or that someone's fucking corrupt and changed the transcript.
And let's amplify that a little bit, because one of the allegations is that in this ex parte meeting, that Judge Glanville essentially, and this has been put forward by Brian Steele, intimidated Copeland and said that you have to testify because Copeland was resisting to testify. And then Copeland had suggested that he was going to go take the stand and say that he was involved in the shooting death of Donovan Thomas. Do you believe that Judge Glanville engaged in witness intimidation?
Well, you know, if you read my motion that I filed on the 12th, I have an affidavit there, and I have the same source as Brian Steele, and that source told both of us that Judge Glanville was involved with the prosecution in coercing Kenneth Copeland to testify, and that is just not appropriate conduct from the judge. Now, the judge is not in a position to refute that, at least on considering my motion to recuse. If he wants to refute that later, perhaps the transcript will show that my source was completely wrong. But again, that's why I've been asking for the transcript. And in the written order that the judge gave us on the 12th of June, he doesn't really deny what I state in my affidavit, which is the same as pretty much as what Brian Steele said in court. He doesn't really refute that in the order. He just says that I lack additional evidence to support that affidavit. But of course, how can I have that evidence if he's refusing, at least at that time, providing the transcript?
How do you think Judge Glanville's been doing overseeing this case, which is a massive case, very complicated case, over almost a year of jury selection? What's your views on how he's presiding over this trial?
Well, I think that he's in a very difficult position. It's a very complicated, complex case that the state has brought. I think he's been trying hard. I think he's been trying to do his best. I believe that I suspect he believes that he's making rulings that are unbiased. And I have tried to believe that that's really the case. But after what I learned occurred in chambers on June the 10th, I'm going back now and questioning a lot of my beliefs. But up until that time, I really didn't believe that he was making his best efforts to handle a very complex and unwieldy case brought by the Fulton County DA's office.
I imagine that you will echo a lot of legal commentators who took issue with Brian Steele being essentially held in contempt of court if the Georgia Supreme Court didn't step in. When that happened, what was your reaction that Judge Glanville was going to hold him in criminal contempt for not revealing the source of the information, for not revealing how he knew about the ex parte meeting? That's why he was held in contempt of court.
I was shocked that the judge would have done that. I think you've heard from people, I'm sure you've heard from people about Brian Steele's absolutely sterling reputation for integrity and professionalism. And when the last lawyer I could ever imagine being in contempt of court would be Brian Steele. So having seen him held in contempt, I was just stunned by that. And I kind of believed it was an effort by Judge Glanville to deflect from his conduct during the morning of the 10th in that ex parte hearing and change the focus onto Brian Steele. Where did you learn of that information, Mr. Steele? That's not really the issue, and that's not the issue that Brian was bringing up. Where he learned of it isn't important. What's important is what happened in that meeting.
Mm-hmm. And let's just finalize it on this point. If another judge, whether it's from a different county or whatnot, decides that Judge Glanville should recuse himself, what is going to happen with this trial? Does it start from all over again? Do you start from jury selection? What do you think is going to happen if that happens?
Well, I can tell you what the law says on a trial where you have a recusal of a judge, which is in Georgia, if there's a recusal of the judge, you're supposed to essentially rewind the case to the point where the judge should have recused himself. When I presented the judge with my motion on the 12th of June and he denied it, at that point, what he was supposed to do was do what he did today, which is send our motion to another judge. He failed to do that. So you have to rewind to that point. I don't see how a new judge unwinds the case to June the 12th. If memory serves me and my notes are correct, the jury has heard evidence from Copeland. There have been arguments. There have been rulings from the judge. How do you unwind this case to June the 12th? I don't see how you unwind this case. How does the jury unhear the testimony from Copeland that they heard? I think it's very difficult to rewind the case at this point.
Wow.
In the YSL train wreck, in the YSL criminal case, that case will be put on hold. For how long? Indefinitely. That's right, ladies and gentlemen. The case that was taking forever is now on hold for we don't know how long. Another judge will be assigned to decide the motion for recusal that was filed by several of the defendants. Now, initially, Judge Glanville had ruled on the motion for recusal, and Yak Gotti's lawyer told him, Judge, at a minimum, you have to send this to another judge. The judge didn't listen to him. They filed an appeal to the highest court with a writ of mandamus. The highest court issued an opinion reminding Judge Glanville of what the rules are. Now Judge Glanville is making a number of changes. He spent the morning in court this morning making a record of everything that he did. Literally, he just went in there and put on the record everything that he did so that the other judge and the appeals will be able to see it exactly. Then he said, I'm not holding an order to show cause hearing. Previously, he told Attorney Bumpus and everybody else who was in the room at the ex parte meeting that you're all going to come in here and somebody's going to tell me who the leaker was. Now he's saying, I'm not going to do that. And he actually said on the record today, I don't need to do that. I'm not interested in that, acknowledging his mistake in choosing that whole line of inquiry. And we'll see. Now, basically what's going to happen is they're going to spin a wheel. All the judges' names are on the wheel. The wheel's going to land on one judge. That judge will decide whether Judge Glanville can continue to be the judge in this case. Stay tuned.
Now the plot thickens. So remember Brian Steele, that's Young Thug's attorney, who was held in contempt by the judge over in Fulton County for not giving over the source of who told him about the improper meeting held between the judge, the prosecutor, and the star witness, Lil Woody. Right? Now, the video I'm about to show you is a video of an attorney that was representing Lil Woody for that day. Right? Now, this video alludes to the fact that she may be the one that the judge is accusing of improperly telling about the hearing. Also alludes to the fact that the Young Thug's lawyer might be right, that there was some coercion here in order to get Lil Woody to testify. Man, listen to this.
Because my attorneys have advised me not to, because we don't know what's going to take place in the show cause hearing. But I will say this, I was under the impression that I was just coming in to see whether Mr. Copeland was going to testify or whether he was going to plead the fifth. And then after that, everything else kind of just happened.
Did you feel like there was anything that went on since you were representing him at that time, Little Woody, and you were his lawyer, his counsel during that meeting? Did you feel like anything happened that would make him feel like he was coerced to get up on the witness stand?
I'll say this, if I answer that question, my lawyers will, probably call me right now and say, hang up the phone. So I really would have to wait until after I see what's going to happen to me.
I'm a lawyer in Atlanta, Georgia, and I have to continue prepping for court. But while I'm on a little break, let's give you updates on the Young Thug YSL RICO trial. The recusal motions have been transferred from Judge Glanville to Judge Krause. There are 3 motions here, and Judge Krause has given the state deadlines by which to respond to each of those motions. Now, as an aside, number 1, absolutely, the recusal motion should have been transferred from Judge Glanville to another judge. That was the right call and should have been the call made in the first place. Number 2, I was certainly concerned about this because it can take a long time to get cases calendared in Fulton County. Fulton County is our busiest county in the state of Georgia. Ginormous, long, complex cases taking place there. And Young Thug has already been in custody for at least 2 years, right? And not to mention all of the other defendants who also are equally as important and should also have their rights protected. So I was certainly concerned about the individuals in question in the trial remaining languishing in custody until another judge could get the cases calendared. But it does appear that Judge Krause is going to move swiftly and quickly. I have no doubt. Listen, if I were the judge in this case, I would want this case off of my docket as quickly as possible. I also want to bring up another point here. It's a question I've had since the outset, which is whether another judge in Fulton County can properly hear the recusal motions. You've got to remember, Judge Glanville is the chief judge of Fulton County. So is there bias there when his fellow judges are deciding cases, judges that he works with every day, maybe helps to train, things of that nature? Can they decide the case fairly? Listen, I don't have any bias for or against Judge Krause or any of the judges in Fulton County. I'm sure that they can make a proper decision putting bias aside, but that is a question that has come up. And I do believe actually that one of the attorneys in the case has filed a motion saying that the case is improperly heard by another judge in Fulton County. So if that turns out to be true, if the judges do decide, yes, well, actually every judge in Fulton County, right, in the Fulton County Superior Court rather, needs to recuse themselves from the case, and that case will be transferred out to another county, maybe Cobb, DeKalb. I don't know what would happen after that, but it's possible that this case gets transferred, at least the recusal motions get transferred out of Fulton County to another county entirely.
I'm an attorney in real life. I don't play one on television. Let me tell you why I think the YSL trial is over. So today, Judge Glanville finally reversed himself, and he said that he was sending the recusal motions, the motions that have been filed by several of the defendants to have him removed from the case. He is sending them to another judge to hear and to decide upon. Now, that process could take a short period of time, or it could take a very long period of time. Just the way the Superior Court cases are set up in Fulton, the court is very busy. They have criminal cases that have speedy trial motions pending. It might be difficult for a judge to immediately hear this case. And if that's the case, we have a jury that has already been in session for 8 months who will just be sitting there, not literally sitting there, but sitting at home, unable to hear the case and still bound by the rules that the jurors have to follow, such as not following social media about the cases, not investigating anything about the cases, not talking to anyone about the cases. We're putting those jurors in a very, very bad position. And then we don't know anything about these jurors, but I would have to assume that some of them have jobs that they need, jobs where they need to be paid. And if that's the case, are we really going to allow them to be waiting a few months just to see if this trial is going to go forward with Judge Glanville? I think this case is over. There is going to be a mistrial at this point. It's over. So that's my prediction, that the case is over, that there is eventually going to be a mistrial, and the state will have to decide if they're going to bring these charges again. Let me know what you think in the comments.
huge update within the Young Thug case going on right now. It's paused. And the reason why it's paused is because there's a different judge deciding right now if this current judge should be removed from the case entirely, which, if he was removed entirely, I believe the entire case would have to start from square one. Maybe not, I'm not too sure, but it would just put, it would put everything up on its head. A new judge changes everything. I can't even believe this. I really can't even believe that this is happening. Now, the reason why is because, there are so many, but I think, honestly, the one thing to pinpoint is with the whole situation regarding Lil Woody and how Brian Steele, Young Thug's lawyer, how he brought, the information that there was witness tampering and there was, a little bit of pressure put on the witness, aka Lil Woody, from the judge and prosecutors. And then the judge proceeded to put Brian Steele in prison, which, sorry, my fire alarm just went off, but that was just crazy in itself. And oh my God, I think the judge is going to get removed. I don't really know shit about law, I'm not going to lie, but from the context and readings I've done regarding this case, I think there's a chance they change judges. And again, let me know in the comments, does this mean new trial entirely?
Hello, TikTokers. Welcome to Real Law Talk. The Young Thug trial just keeps getting worse and more bizarre. Now, one of the defendants has filed a petition with the Supreme Court of Georgia to halt the proceedings. This is, I've never seen anything like this in terms of asking the Supreme Court of the state to stop a trial. That's been going on for 3 months now in a major RICO case. But the legal decisions of this judge are questionable in every single way. The ex parte communication, wanted to have a hearing on the ex parte communication. The Supreme Court of Georgia may do it. There's no path, there's no roadmap for this case because it is such a unique set of circumstances, and it all stems from the incorrect and inaccurate legal decisions that have been made by this judge in a very important case. And this is the administrative law judge. This is the chief judge. This isn't a judge that just started. But he has turned this trial, a serious case, into an absolute circus, and now the Supreme Court of Georgia may have to step in. And that's Real Law Talk.
We have a fucking update on the Young Thug trial, and it is crazy. So if you're ready, like I called it 2 days ago, Young Thug's attorney, Brian Steele, put everybody on notice. He wants the judge to recuse himself. He wants the charges dropped, and he immediately wants a mistrial. He is calling the judge and both ADAs that were present during the meeting that allegedly didn't happen to the witness stand. And y'all want to know what the bomb drop is, huh? That's got him asking for this. So I'm going to tell you. So y'all remember Kayla Bumpus, the attorney who was present at the meeting with the witness in question, Lil Woody? She went and filed a motion asking for the judge to recuse himself as well. So with this new knowledge in documents that are now public, Brian Steele, YSL Brian Steele, served him with a note. The craziest part about Miss Kayla, dropping her motion for recusal, she done blown everybody in. She said, I'm snitching on everybody. I am not going down with this shit. Not today. So the meeting that was alleged, that supposedly didn't happen, that she was present at, she says, because of what was said and what was done in that meeting, I am asking the judge to recuse himself. And what was said and what was done in that meeting? Start off by saying this. That meeting was a backdoor, dirty, rotten meeting full of scoundrels. They were doing some dirty business. Also, we were told that in the meeting there was like very few people. It was the judge, the prosecutors, the attorney for the witness, and the witness. We are now finding out that there was 2 investigators from the DA's office. There was, I think, a reporter. There was a few other people that were there to witness this meeting. So now we have 2 handfuls of people witnessing the dirty dealing. So according to Kayla Bumpus, what was said in this meeting, originally it started out like this. Little Woody came in there and said, I'm taking the fifth. I'm pleading the fifth, just like I did yesterday. I'm not testifying. I'll take the 2 years in jail. I'm sitting there. I'm staying quiet. Well, they turned around and said, okay, Little Woody, you're ready to do the jail time. Well, it's not only going to be the 2 years that you originally were offered. Now you're going to do not only the 2 years, but it's going to be indefinite time. You're going to sit there for the trials of 28 people, 26 now, 26 people. So that could be years and years and years. So are you sure you still want to take the fifth? Or you want to go ahead and tell us what you got to say? Because you're going to be sitting there for a long goddamn time. So now, after threatening the witness in this trial, they offer him immunity. They say, you get up on that stand, we'll give you a little something, something. And you might be able to just walk. He says, okay, I'll get up on that stand, but I'm a lie. He straight up told them, I'm going to get up there and I'm a lie because y'all are forcing me. Their response, cool, bet. Let's go secure our bad guys and take them off to prison illegally. Now, Miss Kayla Bumpus said, no. What is going on here? This is illegal. This is fraudulent. This is all of the grounds for a mistrial. And she's right. So she ran up out of there and said, I want to be recused. I'm not being a part of this. I will snitch on everybody to save myself. And girl did just that. She filed a motion to recuse herself and she did it. Yep, she did. And to go a step further, she said, now I'm going to name each and every one of you that are out here doing bad dealings and behind closed doors, and I'm going to ask that the judge and so-and-so and so-and-so are all recused as well. So she filed that motion right along with Brian Steele. So now Brian Steele has what's called Brady evidence. Brady evidence is something that the defense could use in their defense, and they were robbed of it, denied of it. They were robbed and denied the access to this meeting, which gives them a leg to stand on in their defense. So now he has all of what he needs to file the motion, and he did. All of these things, this is alarming, because if these people within the justice system are at the ready to do such backdoor deals and injustices right before everybody's eyes, imagine the injustices going on that we don't see.
Big news in the YSL trial yet again. Happened all at once this morning when Judge Glanville took the bench. He read from what appeared to be some prepared notes, and a lot has changed. First, he says that he is releasing the ex parte transcript completely unredacted. If you'll recall, he had tried to say earlier that he could redact it for purposes of making sure there wasn't any privilege in there. We all knew that was a garbage argument. There was no privilege in a situation like that, and now he has admitted that, and he is going to release it unredacted. He then went on to read from a bunch of case law to try to justify why he had the ex parte meeting in the first place. He says the case law says that as long as no party gains a tactical advantage through the ex parte, there was no substantive testimony discussed, and that a transcript was created, which it was, that he says that the ex parte was fine, and we will see whether the defense attorneys don't continue to argue that it was not fine. So there's that issue. He then said, and I thought this was so interesting, he mentioned that he saw security video of Kayla Bumpus meeting with Brian Steele and some other lawyers after the ex parte. He is no longer having the order to show cause meeting that was supposed to come up, order to show cause hearing to find out who the leaker was, because he obviously knows that it was Kayla Bumpus. He doesn't seem like he is seeking any retribution against her outwardly, but he did say he, quote, takes no position on whether Kayla Bumpus violated any privilege or confidentiality, but he'll leave that up to the state bar or the appeals courts. He also said he takes no position on whether Brian Steele violated any rules of professional conduct by discussing it in open court. I was not a fan of Judge Glanville saying that at all, because it is incredibly passive aggressive in terms of what he's implying about these lawyers and their behavior, when I certainly from my standpoint didn't see anything wrong with what they did at all. So that was pretty low, if you ask me. He then went on to say that upon further consideration, which is judge speak for I screwed up and I'm going to try to fix it, he is now going to allow the motions to recuse to be heard by a different judge in the Superior Court. Yes, still his colleagues, but he is going to allow it to be wheeled, which means that the Superior Court clerk will randomly assign it to a different judge to have all three of those pending motions to recuse against Judge Glanville heard and decided upon. So he is feeling the heat. He can see, I think, both based on the fact that the Georgia Supreme Court kicked back that writ of mandamus and said, y'all ought to go ahead and start through the Superior Court on that, plus all the other commentary that's out there, including, people like us on social media, that he is realizing he needs to have this heard by someone else. So we will keep you updated. In the meantime, that poor jury and those poor defendants, now the case is on pause while we have these motions to recuse heard. I'll keep you updated.
Baby, the judge just sent the recusals to another judge. Kayla Bumpus ain't got to go to court. Judge Glanville has been scared straight.
If you are watching the YSL trial, we have been placed on pause. Pause. Yes, we are on pause, y'all. So, Pete, we had court today, okay? It was light, but it packed a lot of punch, okay? A lot of punch. First up, Glanville went into the ex parte meeting. He said that the transcripts will be released from the ex parte meeting. So we finally get to see what went on behind them chambers with Woody. Did the prosecution really threaten him? We shall find out very soon. Next, the judge went into the recusal motions. He said that he's going to place a court order to have another judge review the recusal motions that were placed by the defense. Yeah, he's having someone else take that on. We may get somewhere. We may get somewhere. But now the problem is he has put all court proceedings on hold until we get some kind of answer to these motions. Yeah. Thug is in there sitting while they reviewing motions. Yes, 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 yes. The jury wasn't expected to return until July 8th. So it may be done before then. It may not be. But the judge says there's no timeline on when they can come back on this motion. We won't have any YSL updates for a little while now unless Woody does something crazy. Till then,
YSL update. So you remember the judge had issued an order saying everybody who was at the secret meeting come to my courtroom and decide who told people that we met in secret. I'm not sure if he's allowed to do that. He might be having second thoughts about doing it because he's postponed it. He was going to hold it this week. Now he told everybody we're going to do it next week. I'm going to show you a video from the lawyer for the witness who was in the secret meeting. Watch the video. It does not look like she has any problems talking about the secret meeting. In fact, I'm not quite sure why the judge thinks that people who were at the meeting can't say that they were at the meeting. The only person who has a problem with people knowing about the meeting is the judge. Watch what the lawyer says. She's like, yo, I'm ready to talk about it. We went there for completely normal purposes, and what happened was not that.
I asked Bumpus to kind of take me inside that meeting.
So I'm not really able to speak on what happened in that meeting just yet, because my attorneys have advised me not to, because we don't know what's going to take place in the show cause hearing. But I will say this, it was a situation where, like I said, I was under the impression that I was just coming in to see whether Mr. Copeland was going to testify or whether he was going to plead the fifth. And then after that, everything else kind of just happened.
You heard her. She said, hey, I went to that room to hear whether or not my client was going to testify. Now, we've heard that Copeland started that meeting and said, I'm not going to testify. And then everything the defense is claiming, outside their presence, outside the presence of a jury, behind closed doors, witness intimidation.
Listen, I know that's what we want. Initially, that's what I wanted to do too. As soon as it come out, I wanted to e-file it and the e-file comes out, I wanted to run around, find it, read it, and we can just go over it. But I'm going to wait. I'm going to let everybody else do that, but I'm going to wait, and I'm going to tell you why. Shout out to ShamWow, because she reached out to me. She said, I know you in the car. I know y'all out riding. I am not driving. I know y'all out and about, but if you can, jump on to the other platform, look at the lead attorney, because Ms. Bumpus is on there, and she's talking. Now, it was live, so I did not get to see all of it, but I saw a part that stood out to me, and I'm going to tell y'all why. Because y'all know me, when I see Glanville or anyone start to outline, start to outline a time, why are we running down a whole timeline? Why are we putting things in perspective? This is like a disclaimer to me, right? But he said they came in at 9-something. I missed that time. And then he said that the meeting had to be halted because they were waiting for Woody. Then Woody was brought over at 10:03. Then at 10:03, the meeting started. But then after the meeting started, I missed the next time. And once I started realizing he was saying all these times, y'all, I went back and started putting together these times. And the time that stood out to me is he said from 10:17 a.m. to 11:28 a.m., Woody was having a private conversation with Miss Bumpus.
And I know we all want to wait for the transcript to come out, but once it's available, I'm not speaking on it until Ms. Bumpus speaks on it. I will be back at the lead attorney because she said she would come back there and speak on that. And if there is an hour, because she knows what was going on in there, and if that 10:17 a.m. to 11:28 a.m. was not a private conversation, but it is an hour or chunk of information that we are missing from this transcript, and this is how they figured out how to get it out of there. Glanville, and again, okay.
Woody starts it out with, "Can you let him know I got a hearing problem?" And Kayla says, "Okay." He said he is hard of hearing. And the court says that makes two of us. I've got a hearing that's coming on the 27th of June. So I'll try and talk loud. Okay, Mr. Copeland, I just wanted to bring you over and let you talk with Miss Bumpus and see if there's anything you need to ask of your counsel or Miss Hilton or the state or the court before we bring you out this morning, because we would like to hear your testimony, and that is kind of where we are at this point. So that's how he starts it with Woody. Woody is now in the courtroom here. Thanks everybody for tuning in. Thanks for your love on TikTok. Love how TikTok's like the casino with all the gifts and everything. So is there anything you would like to ask? Judge Glanville says, and Woody says, "Well, I want to speak with you personally that I have never been truthful a day in my life until I..."